Hello friends, in the series on the income tax matters, today we will discuss a very important issue on TDS deducted by deductor but not paid by him, due to which the deductee has to face the demand of the revenue. So in the circumstances where the deductor do not pay the TDS, due to which the TDS is not reflected in the 26 AS of the deductee, and if the demand comes, then what is the avenue available to the assessee and whether the assessee has to pay the tax in that circumstances or not. This issue has been taken by Honorable Delhi High Court in the case of Incredible Unique Buildcon Private Limited versus Income Tax Officer. This case has been reported in 470 ITR, page number 106, and the date of the judgment is 3rd October 2023. There are various sections in Income Tax Act which are not very frequently talked about in seminars, in various lectures, but they have very big importance in determining the tax liability of the assessee. There is one section, section 205, which talks about bar against direct demand on assessee. This is the title of the section, and the crux of the section is that this section is very small, only running into 3 lines. This section says that if the TDS has been deducted by the deductor, then it is immaterial that whether he has paid that tax or not. And if the deductee proves that the tax has been deducted, then the revenue cannot claim this tax amount from the deductee. In the present case, the tax was deducted, but it was not reflecting in the 26 AS of the assessee, and Form 16A was not issued by the deductor. And more importantly, the assessee has filed a complaint against the deductor on 25th January 2017 that my tax has been deducted but it is not paid, due to which it is not reflecting in 26 AS. But unfortunately, as usual, the revenue has not taken any action. But the demand was created, for which the assessee was before the Honorable Delhi High Court. Delhi High Court said that in the present facts and circumstances, there is no dispute that the tax has been deducted because the assessee has submitted the ledger of the deductive with the deductor, and the court said that if the tax is deducted, then it is immaterial for the deductee that whether that tax has been deposited or not by the deductor. And the court also said that it is also immaterial that whether the Form 16A has been issued or not. The court further said that there is no denying the fact that Form 16A is a piece of evidence of tax deducted, but the court simultaneously said that Form 16A is not the only piece of evidence for demonstrating that the tax has been deducted. Since in the present case the assessee has filed the return of income and claimed the TDS and also submitted the ledger with the deductor which was showing that the tax has been deducted, and more importantly, when the assessee has filed the complaint, then in that circumstances, if the TDS is not deducted, if the TDS is not deposited by the deductor, then the court said that in that circumstances the assessee, that is the deductee in this case, cannot be left open to the mercy of the deductor, because the court said that there may be multiple reasons that the deductor has not deposited the tax or is not issuing the Form 16A. So the court said that it is very much clear the intent of the legislature that it is not in the hands of the assessee that whether the tax is deposited by the deductor or not, so he should not be penalized for that, and the benefit of tax deducted should be given to the assessee, and the demand cannot be collected from the assessee. Friends, this case is very important as far as for those cases where the assessees are suffering due to non-deposit of the tax by the deductors. At the end of this video, once again I am repeating the name of the case. The name of the case is Incredible Unique Buildcon Private Limited versus Income Tax Officer, and this case has been reported in 470 ITR at page number 106, and the matter has been decided by Honorable Delhi High Court, and the date of the judgment is 3rd October 2023. Thank you, friends.